Number 4, was this free?
In its detailed judgment, the Apex Court stuck through its prologue in giving the reasons behind ratifying President Uhuru Kenyatta's victory. Among the key pointers that the court was seeking to expound was on the fresh nomination that the petitioner number 2, former Kilome MP Haron Mwau, sought his prayers on maintaining that the first respondent defied the Constitution by having a fresh poll without nominations, a matter that the court interpreted differently. The withdrawal of NASA leader Raila Odinga that predominantly led to the boycott of 25 constituencies in the poll, as well as sparks of violence in some counties, would also form fodder for the petitioner prayers. This bringing forth the question of the legitimacy of President Uhuru Kenyatta.
In view of our observations in the foregoing paragraphs, it emerges that the withdrawal of the candidate from the 26th October 2017 fresh presidential election could not, in law, have occasioned the cancellation of the elections. That settles issue number.
Mere apprehension of the breach of peace may trigger the exercise of this power. In the instant case, it was actual and not imagined threat of violence in the affected areas. Therefore, the Commission's actions were not outside the contemplation of the law.
Is that the election held on the 26th of October 2017 was credible and met the constitutional threshold that is required of a presidential election.
According to the unanimous decision by the bench, it was also found that the evidence submitted by the petitioners was not admissible, hence lacked the constitutional merit.
Which law is applicable for purposes of determining the present dispute, and whether Section 83 of the Elections Act as amended is unconstitutional and invalid. In consequence, the petitioners sought a declaration that Section 83 of the Elections Act as amended is unconstitutional and invalid to the extent of its inconsistency with the Constitution of Kenya.
The Election Laws Amendment Act 2017, Act 34 of 2017, not having come into effect as at the time of that election, and the same not having had retrospective application.
In a concurring opinion by Justice Njoki Ndung'u as well as the bench, it pronounced itself on the Election Laws Amendment Bill that they say did not have a legal effect on the poll.
Various counsel for the petitioners spent most of their allocated time addressing us on collateral issues instead of laying evidence and discharging the burden of proof by addressing the respondents' written submissions.
Unlike the nullified August 8th presidential election that the court found massive irregularities and illegalities on the conduct of the IEBC has today been vindicated in the detailed Supreme Court verdict of the October 26th poll, reiterating that the IEBC conducted the elections under the dictates of the Constitution. Dina Matengo, Ebro TV at the Supreme Court buildings.